meeting of the Ojai Basin Groundwater Management Agency to order at 5 o'clock on March 27th. And I call the roll.
Director Daddy?
Here.
Director Whitman?
Here.
Director Finch?
Here.
Chair Hages?
Here. I'm going to skip through to public comments. Are there any public comments on items that not appearing on tonight's agenda? Okay. We'll move to item 4, which is board hearing to consider imposition of fine and or civil penalties to be assessed against the owner and operator of the state well located at 241 Saddle Lane, Ojai, California.
It's 741 Saddle Lane.
741, okay. Julia?
Good afternoon. So as I mentioned during the regular board meeting, this hearing is a result of our efforts to get well owners in compliance with our meter ordinance. We started this process in November by sending out first notices, giving everyone 90 days with a deadline of January 30th, 2025. We sent out second notices, final notices. Through that process, some people got their meters installed, sent us the registration forms and the photos. We took them off the list. We also, you might recall, had some members of the public come who had backup wells or wells that weren't functioning and wanted to have some kind of exemption process. There's maybe a dozen of those. Where we are now is 2 remaining wells that are not in compliance and have not communicated with us. The first one at 741 Saddle Lane, you can see kind of the paper trail of the notices that were sent and the confirmations from the post office that all those notices were received. We got on Monday, CC found an envelope on the counter at the reception of the office building where our office is located from, it appears, the owner of 741 Saddle Lane. There was a lot in that envelope. The one that deals with the meter is the one dated March 1st of 2025. But please keep in mind, we did not get it until Monday, which was March 24th. I'm not sure who SC is signed on the letter or initialed on the letter. The records that we have is that the owner is Therese Van Landit, and that's who I've spoken with on the phone one time about this. Actually, I had spoken to her about being delinquent on her reporting. So we got that letter. If I'd like to focus on the March 1st letter and go through the points that were raised in it. So she did enclose some checks. It seemed like in an attempt to get her account brought up to date. However, even with those checks, it is not up to date. The delinquencies go back to 2016. So she mentions, or the letter mentions, that checks were hand-delivered to me personally. I have never met this person in real life. I have never received any checks. So that is not an accurate statement. Mentions checks dated 5/1/24 that were paid in advance for the second and third quarter of 2024. We don't accept checks in advance. They come with the statements so that they're accurate for the water usage. The second paragraph says that they received, that supposedly OBGMA received multiple confirmations of a property well flow meter. This is also not true. We have never received any documentation for a meter on that property. This is the actual folder. This is the hard copy of all the records we have for that well. We have one for every well in the office. What we have in this folder is the well permit application from 1998 from the county. There's then a water well field data report that apparently OBGMA used to send out to people with some photos. And this is from 2002, and it clearly says under the well meter section, none at pump. So as far as our records show, there was never a meter on this well. When we sent the notices, we sent meter registration forms to them. They were required to fill them out, send them back with a photo. The letter that was received on Monday also had photos of a meter that were black and white copies. It does look like a meter. It looks like a metal tag with a serial number on it, but we cannot read the units, whether there's a meter multiplier on it, can't read the numbers on it. They're basically useless photos to us to document that there's a meter on that well. Again, the memo states the communications that we had with the owner. I'm recommending that we impose the one-time fine of $500, and then it is up to the board's discretion of what the daily civil penalty would be. The ordinances do allow up to $1,000 a day. It's been 56 days from January 30th to today. And there is a resolution attached to move forward with whatever the board decides.
I'd like to add real quickly that with regard to the packet and the photographs of the meter, there's no way to tell from the photographs that this meter is associated with the well in question, right? It's something that looks like a meter, but there's no indication that this is the well that we're concerned about. And secondarily, there's no way to tell from the pictures that this is an operable meter. And I believe that our ordinance assumes that, when you have this metering requirement, you're going to be installing and working with an operable meter and not one that's doesn't work at all. So in my opinion, there's nothing about the photographs or the packet of materials that were included with the letter that demonstrate that this well operator is in compliance with the metering requirement.
And the statements that have been turned in there are no meter readings on them. They're based on irrigated acreage.
I have a question. And this is on the December 6th, 24. This is in paragraph 3. Per OBGMA legislation ordinance 8, a one-time $500 may be assessed. It goes on to say, in addition, OBGMA has the authority to impose civil penalties up to $1,000 per day for each day beyond 90 days. Is that correct, or is that prior?
That's what the ordinance, I believe, says.
Well, no, I mean, in order to impose the daily penalty, you have to first establish a compliance deadline, right? And so the December letter went out. It was the second notice, and you'll see at the top, in very bold print, it says deadline for compliance January 30th. So here we're sending 3 notices to the owner operator indicating that they have until January 30th, 2025 to install a meter. When that date came and went and there was no compliance, that's when the clock starts ticking on a daily penalty that could be assessed by the board.
Where does the 90 days come in?
That's that.
What date?
The
January?
90, so the first notice of required compliance letter went out
In November
beyond
1st.
90
November
days
1st.
before January.
Yes.
Okay, so is that the day, November 1st?
November 1st is the date of the first notice. 90 days from that was January 30th.
Okay, so we've had this thing sitting around since 98, and when did the OBGMA adopt or have rules that meters, in fact, were required? How many decades has that been?
I believe that the ordinance first went into effect in 2011. Let me
Okay, 14 years.
check what the date of the ordinance
Okay.
is.
And so this notification, we're sitting from November 1st to now to almost 150 days,
Correct.
right? A couple more days, 150 days even?
Yeah. 146.
Any other comments or questions? Is there anyone on representing this property that would like to make any comments? Okay, the next item for discussion then is what level of civil penalty you want to consider. If there's,
I would like to, to make a motion that we, as recommended and as our ordinance call for, the $500 and the $1,000 a day for as far back as we can go. We need to incentivize this. And this person has spent a lot of our time and a lot of our money and a lot of our staff time and a lot of efforts. And this is the person that's defiant, that has told our staff that they're gonna sell their property and there's no way we can collect the money they owe. So I would like to see the maximum penalty, maximum daily, and put a lien on this as soon as possible.
So let me just, maybe this would be helpful, this information. So this is not necessarily the only opportunity the board's gonna have to look at this. The board can schedule a hearing in a month or 2 months or 3 months to come back and revisit the continued non-compliance. At that point, you could escalate, you know, the penalties. So you have that option, right? And I'm just saying, you don't necessarily need to lead out of the gate with the most severe penalty possible. But that's up to the discretion of the board, and the board should talk about it.
So the recommendation was $20 to $50 per day. And I'm wondering about Mr. Daddy's suggestion that we go to 1,000, and how those two different concepts, you know, jive with what we're doing.
I think it goes to Peter's point. We got their attention. They did provide something. It's not adequate. And there was a point in the letter where they said that a meter for installation has been ordered. There's, again, going to be more follow-up to see if that actually happens or not. So I think there's maybe some opportunity, like Peter said, to keep going after, go back again.
how many days is it?
56.
56 days.
56.
And just as another point of clarification, so there's been 56 days from the compliance deadline that was established of January 30th, 2025 till today. So at $1,000 a day times 56, that'd be a $56,000 penalty.
Yeah,
I'm-
go ahead, Jim.
I don't think, I wouldn't go there. I mean, I understand where you're coming from, Bob, but I think that won't in the end get us what we really want is everyone in compliance with having metered wells and reporting them properly. And I think we've gotten some people awake. We got a lot awake.
We did.
We got a lot awake, and I even have seen several of the meters installed. There's a few that now we need to push along a little harder. And I would be more in the realm of, you know, anything that's ticking, any meter that's ticking, I think eventually gets their attention. And as Peter says, we can revisit it in 90 days or something. I would be more in the $20 a day range.
The $20 would be $1,120. 50 would be $2,800. I think what we need here is
And then we're doing 500 on
And the
top.
Plus
500.
500.
and 500 on top of that, yeah. Well, what we need here is a motion to adopt resolution number 2025-1 with a $500 penalty and a fine or a civil penalty per day, whatever the motion is.
Chair, I'd like to ask a question of our general manager. How much money do you think the OBGMA has spent with all of the staff, legal, you, other staff involved in this one particular case? How much money are we in arrears? Are we in arrears $5,000 more?
On just this issue, the meter compliance one for this property?
Just this property.
Well, this property has the meter compliance as well as the quarterly statement compliance. They're two separate issues, but both still problems. On just the meter compliance issue, I'm expensive. Probably $1,500, $2,000 of staff time.
And attorney.
And attorney, you're right, and attorney. So I would add another 1,500 to that.
And what was the number if we do 50 per day? Is it 2,200?
$50 a day, it'd be $2,800 plus 500. at
33.
So we'd probably break even on what we're talking about expenses if we do the 50 a day.
Yeah.
I don't see that's much of an incentive, is it, for people just to break even? It doesn't force compliance.
Well, assuming they're not gonna comply tomorrow, the
Tomorrow,
clock starts ticking again.
Or keeps ticking.
Keeps ticking,
Keeps
yeah.
ticking.
I would not like to let this thing wait 90 days. If someone's going to make a resolution and we have to adopt it, I would like us to bring this back up in 30 days. If given this consequence and given the fine and given the severity of this, if they can't figure it out in another 30 days, again, this is a 2014 rule. It's 11 years it's not been complied with. And years of late payments and canceled payments. So, this isn't a hard case when you're selling your property for $8 million. This is not a
That's-
charity or poverty.
That's,
So, I would hope that we would, again, make this thing what it is, a lesson, so we don't have to go through this with anybody else. So, thank you.
I need a motion.
So I'll move that we adopt the $500 penalty as well as the $50 per day penalty. And, I'll entertain bringing it back as well in that motion if Mr. Candy supports that that's the right procedure we should be following to, be aggressive about enforcing.
I think if I understand your question correctly, yeah, I support that. I think that's an appropriate way to go. And again, the issue can be revisited by the board and ramp up the penalties, as you go forward.
Yeah,
The
I guess
board
my question was
also-
how many days should we say we bring it back to check on whether we've brought the person into compliance?
I think you can adopt the resolution and then direct staff to bring it back in 30 days.
Okay. That's my motion.
Sorry for missing your point there.
Yeah.
I'll second the motion.
Okay, this is a motion to adopt resolution number 2025-1 with a penalty of $500 and a civil penalty of $50 per day for 26 days. Call the roll.
56 days.
56 days. What did I say?
26.
Oh,
Director Daddy,
Yes.
Director Whitman,
Yes?
Director Finch,
Yes.
Chair Aegis.
yes.
I have a clarifying question for that. Does it need to be another hearing that I bring
That's-
it back to the board
That's what I was
with
gonna ask.
30-day notice to bring it back again?
I think it's just direction to staff. I don't know that
Okay.
it needs to be anything
But
formal or made in a
Okay.
motion.
if you were going to, I guess this in discuss, if you were going to increase it, then it would need to be a formal hearing probably.
Oh, okay, I
Yeah, for the next
apologize,
step.
I guess I'm not
So
understanding
the
here.
50 is running, and that clock, that meter is running.
Yep.
I mean,
The 50 has been assessed.
has been
By the-
assessed and is continuing to run.
No, there's no continuing to run. So the clock resets tomorrow as the first day, and you can come back at any point in time in the future, and on that date, then assess another penalty for whatever amount you
Period of
want
time has
per day.
passed. For the period of time that has passed.
Okay.
Do we have to go through a process to give them X amount of notification or leniency, or do we have to jump through any hoops, or can we come back in 30 days and then assess the $1,000?
So 30 days, it's a good question, maybe a little tight, because we're required to give them at least 30 days' notice of the hearing. We don't need to keep sending out letters, new compliance deadlines. We just would give them another 30-day notice. We'd set the hearing for, 31 days beyond that, or whenever it would be, and then the board could come back and look at those number of days and determine the amount of the penalty to pose per diem, per day.
I would suggest we bring it back with a staff report in the next board meeting
Okay.
with an action item to set a public hearing to
So it-
apply another fine. You get twice as much.
Could we have set an ordinance that said $550 a day, and at the end of 30 days, if there's no compliance, can we set a future amount now where it just automatically jumps up? Every 30 days, it doubles or goes 5 times? Every 30 days until there's compliance?
We haven't.
Well,
Gotta ask what
so
the question
I
is.
wanted to avoid, I think the board's in a better position if they're not imposing prospective, forward-looking, escalating penalties. I think that invites litigation. We might not be able to defend. I
Okay.
probably shouldn't be speaking out loud about that. I think the board is safer if it looks at a period of time that has gone by without compliance and establishes a penalty for that time period, and then comes back later, looks at the next time period, establishes a penalty for that. And by the way, all of this, we're looking at putting on the county tax roll as a collection mechanism. So just keep that in mind as well.
Right, so there's the lien.
I've got to admit, even though I voted yes, I had a little bit incorrect understanding. I thought the meter kept running.
Well, I think we're still able to penalize for every day beyond.
I thought it just, we're assessing $50 with the meter running. It's starting as of July, or January 30th, and we're at 56 days, but tomorrow is 57.
Okay, so what I'm suggesting is the board come back, and if $50 is the appropriate penalty in the future, that can be assessed, or any amount in the future. But the clock or the meter is running on non-compliance, okay? But not necessarily on the penalty.
Okay.
The penalty gets imposed at intervals
Okay.
over the
All right.
course of time.
Thank you. Then now I'm clear on my understanding is now clear.
Okay.
So the clock is ticking, but you take segments in time for the penalties.
Correct.
I think that's the most defensible approach.
Okay, understood.
And I think in order to make sure that we're in compliance with the number of days we have to notice a hearing, that we direct staff to bring this item back at the next board meeting to set the public hearing and the notice for the following, if we don't have compliance.
Trying to pencil that out in my head with the calendar and make sure that there's 30 days in between the board meetings, because sometimes there isn't. So I'll have to make sure.
Late May-ish.
Yeah.
We could vote to push the meeting back a week on that, just to
Yes,
be able to
just
do
make
the
sure.
notice.
Yeah. Rather
Or-
than waiting
or
for
have-
another board.
Or
meeting.
have one early, right?
Yeah,
Just as long as we got the 30 days.
And- Okay. All right, so we're finished with 2025-1.
yes.
The next item is consider a public hearing to consider imposition of fine and civil penalty to be assessed against the owner-operator of the well located at, was it Ladero Road? 1224 Ladero Road?
26.
1220, I got some kind of a problem today.
Your glasses are right there.
1226 Ladero Road.
Did I say that out?
Better not do any bookkeeping today.
And
Oh, yeah.
this is the same property owner, correct?
No, this is a different property owner, different property. This one is owned by the Villanero Trust.
Okay.
Follow the same schedule of first notice, second notice, final notice, notice of board hearing. The communication was a little different. It appears that this property is managed by a, some kind of management firm. Their address, you can see on the notices is, find the right one.
You're
It's,
talking about 2049 Century Park, Suite
yes,
1400
it's in
LA?
LA, yes,
Properties on 1226 Ladera.
correct. Did I attach the right ones? It looks like I might have, not done the attachments properly. I apologize for that. The Villanero Trust, did have all the same noticing that the previous one did. It looks like I attached the wrong notices. I do still have them, though. The only difference with this one is that I did speak with the business manager, was able to track someone down after numerous phone calls. He indicated that he had only recently taken over the account and was trying to get up to speed on all the loose ends that need to be tied up on the property, but that he would make it a priority to install a meter. That was on on March 3rd. I called again on March 14th to follow up, and I haven't heard anything since then. Have not gotten emails or phone calls or any paperwork in the mail from them.
Okay. Do we have anybody representing this property that would like to comment? Okay, board.
Julia, was this property brought up to date on September 30th? Current,
On
was
their-
everything paid
They
on
have,
the 30th?
they have been current on their, let me make sure I'm saying that right. The last quarterly statement we got from them was for the quarter ending September 30th of 2024. So we did not get the one ending December 31st. They're behind one statement.
And pretty soon, too.
We just sent out the statements this week, or Friday.
So have they been reporting and paying up to that date? And that's
Yes.
fine? And they're just a little arrears?
Yeah, and they were reporting on the total irrigated acres and the irrigation factor.
Okay.
So the only issue is they don't have a meter.
Correct. And it is a large property. It's 3 acres, and they own an adjacent property that's 5 acres. So it's 8 acres. I have no way of knowing how much they irrigate, off of the well itself.
Well, I'd make a motion that we adopt resolution
2025-02.
dash 02 at the 500 fine and $50 per day, what that works out to.
It's 2,800 plus 500.
A second?
Call the roll?
Director Daddy,
Yes?
Director Whitman,
Yes?
Director Finch,
Yes.
Chair Hedges.
Yes. Any other comments? Okay, the public hearing is adjourned.